Namaste, friends, and welcome to the Saturday edition of Legal Words of Wisdom, Nyay Gyan Ganga, on our Virat Hindustan Sangam social media channels. As you know, we are thankful to Dr. Subramanian Swamy and Dr. Venkat Iyer for being with us every Saturday to discuss something or the other of law which will help the common man to understand law better. So today we start as usual another episode, which is episode number 17. As you know, we started this about 4 months, approximately about 4 months ago, and we have reached episode 17. We have our legal words of wisdom on every Saturday at 8 p.m. and we have a regular words of wisdom, regular words of wisdom, which is also known as Gyan Ganga on Sundays at 8 p.m., where Dr. Swamy talks on a topical subject. Today, we are going to be discussing copyright. Is it a help or hindrance? Copyright has the potential to bring a lot of benefits, including to developing countries like India. But it is a concept which has not always been properly understood. What is copyright? How does it protect and how? Is Indian law on copyright fit for purpose? What are the main principles on which the law operates? How can a person stay on the right side of the law? What are the penalties for breaching copyright? These are some of the issues that will be discussed in today's episode. As you know, Dr. Venkat Iyer is an Indian-born lawyer, academician, and a media expert who's based now in the UK. And VHS is grateful to him for he having devised and running this program for Virat Hindustan Sangam for our common people to understand law. And Dr. Swamy is with us. He will have the opening remarks and then we will be having the full discussion with Dr. Venkat Iyer. I thank our viewers across the globe for their support and viewing these episodes, and we are getting support daily. We request you to contact us on our website www.vhsindia.org and also follow Dr. Swamy and our VHS India at the rate VHS India, the Twitter handle, and at Swamy 39 for his Twitter handle. So with this opening remarks, it's over to Dr. Swamy. I thank my co-host Ramesh Swamy, and also I thank our technical team led by Ashish Shetty, Vishal Mehta, Ishwar Iyer, Tejas from Pune, Rakesh Gadgi from Karnataka, and Swaminathan from Chennai for their background support and help for putting this program and contents together. Thank you, and over to Dr. Swamy.
Well, thank you very much, Jagdish. Dr. Venkat is one of the foremost in the legal profession from not only from India, but he has made a big name. He has held official positions in the government there in Northern Ireland. And I think also perhaps you had a tenure in Dublin also, if I'm not wrong. But maybe it's very confusing to have Northern Ireland and Ireland at the same time. But anyway.
Belfast.
Belfast, yes, that's right. This is a intricate subject. And the whole object of this session is to see it simplified for people to understand. It's very well known that you can't copy somebody else's work. But the question is, what does copying constitute? And the bottom line of the intellectual property thing, because I dealt with it as a commerce minister when we, worked on during my tenure, the WTO draft and everything was worked on during my tenure. I went also to Brussels for the final international conference. So the issue was discussed very thoroughly. that what do you copyright? An original idea. And that idea has to be in a sense that never before it was formulated or propagated, and then therefore nobody else should then later on just copy that and then produce it as his own work. You can't help if after all, if you using English language, so the sentences may be the same, but the idea, the concept, these are when they are new, they need to be protected because you have put in so much effort with so much trial and error to get it. So it's like a property, and that's why it's the broad term is intellectual property. So, on the other hand, you have people who will file cases against you and drag you to court and harass you, and you will probably regret that you ever made anything original, and then be in turn around and being accused of having copied from this volume and that volume and this study and that study. So, I think what we are looking is to demystify this copyright concept in the background of the intellectual property legislations, and so that people know which is the Lakshman Rekha that you can't cross, and so that you don't get into damaging litigation. So over to Venkat Iyer to instruct us on how he views the subject. Venkat, it's yours.
Thank you, Swamy. The topic that I plan to discuss today is, or at least should be, relatively uncontentious. Copyright is an area of the law which does not threaten people's freedoms in the way that, say, hate speech measures do. On the contrary, copyright law protects people's interests in a fairly benign and, I would say, mutually beneficial way. It is also an example of a law where there is a commendable amount of international cooperation without any visible friction. Every day, millions of transactions take place around the world in which copyright law plays a constructive or at least facilitative role. Now, you're probably beginning to think from what I've said so far that there are no difficult issues to discuss in relation to copyright law. Unfortunately, that would be a bit optimistic because copyright does present some challenges in certain parts of the world, including India. And the challenges are essentially those of enforcement and specifically about non compliance with the law. So, although my talk today is going to be largely positive in tone, I will be referring to one or two uncomfortable facts as well. Let's first try to understand what copyright is all about. In simple terms, it is a property right which can be enjoyed by both individuals, that is, natural persons, and corporations or legal persons. But it is a right to intellectual property, not physical or tangible property. So we are talking about property that comes from the mind or intellect, and it relates to creations like artworks, essays, music, or plans for buildings. If I were to explain the difference with a simple and probably simplified example, imagine you're listening to a song on a radio. The radio is physical property, but the song is intellectual property. Now, intellectual property may seem a bit abstract to some of you, but it is just as important as physical property. From the point of view of individuals, it protects the creators of artistic and literary works from being unfairly denied the fruits of their labor. It also acts as an incentive for authors to create new works and thus aids cultural progress. It ensures that the remuneration which is due to an author is shared equitably among the ultimate consumers, for example, purchases of books or computer software. It provides a simple solution to the complex problems of remunerating authors across national boundaries. Now, from a national, that is a country's point of view, it helps to strike a good balance between the legitimate needs of society for access to material of importance for the enjoyment of a full life on the one hand, and the equally legitimate right of creators of such material to reward on the other. And don't forget that it promotes national prestige by giving the protection necessary to enhance the cultural heritage of a country. An example in this regard is the preservation of ancient statues, idols, and paintings. There are various types of intellectual property, such as copyright, patents, trademarks, and trade secrets. But for reasons of convenience, also for reasons of manageability and ease of understanding, I'll confine my discussion to copyright only. This form of intellectual property is what most people deal with on a day to day basis. Let me first say a few words about the basics of copyright. In simple terms, it is the right to exploit one's own creative work. And it is based on a recognition of skills, labor, and the investment of time. It is available for literary, artistic, musical, dramatic, and other works. So, this includes books, newspaper articles, poems, paintings, sculptures, architectural designs, engravings, photographs, cartoons, sketches, movies, plays, even mimes, computer software, and so on and so forth. The list actually is very long. There is one important qualification about copyright which I want you to keep in mind, namely that copyright only protects the form in which an idea is expressed, not the idea itself. I shall explain this point at greater length a little later. Copyright is particularly important for journalists, but it is a double edged weapon. On the one hand, journalists can use copyright to prevent others from unfairly copying their work. But on the other hand, they may find themselves in trouble if they, deliberately or accidentally, copy other people's works without their permission. And as I said a couple of weeks ago, copyright can also be used to protect an individual's privacy. How, I shall explain shortly. Now, staying with the basics of copyright, I want to make one or two more points. Firstly, that copyright is governed for the most part by statutory law. And as it happens, by a law which was made by the Indian Parliament after independence. This law is called the Copyright Act of 1957, and it is a comprehensive law. Secondly, copyright law is both civil and criminal in nature, which means that if somebody breaches copyright, they can be both sued for compensation and subjected to punishment, including imprisonment and fines. Another interesting aspect of copyright law is that protection is afforded to foreign works as well. As long as the work is created in a country that is a member of what is called the Berne Convention, it enjoys reciprocal protection without any need for extra formalities. And the Berne Convention covers, I think, 179 countries out of the 195 or so currently in existence. This is good for Indian authors as well. So, for example, the book that Swamy recently published on China cannot be plagiarized by anyone in any of those countries, including China. And he doesn't have to do anything special to enjoy the protection. There may, however, be problems of enforcement, which I shall come to towards the end of this talk. Let's now look at the key principle I outlined earlier, namely that copyright protection does not extend to ideas, but only to the expression of ideas. This is unfortunately not understood by a lot of people. It means, among other things, that there is no copyright in historical facts or themes. Perhaps the easiest way I can illustrate this is by pointing out that many movies or television serials or books are made of the Ramayana. Now, the core idea of those movies or serials or books is contained in the Ramayana, but each of them treats the subject slightly differently from the others. This means that under the law, every movie, every TV serial, every book on the Ramayana enjoys separate and distinct copyright. This is based on a recognition that each person who has made those versions devoted his or her own skill and labor to the expression of the idea of the Ramayana. This principle can lead to some difficult situations. So, for example, if an artist were to sit in a certain place facing the Taj Mahal in Agra and make a painting of the monument, and if another artist were to occupy the same place later and make his own painting of the monument from the same angle, clearly the two paintings are likely to be very similar, even identical. And yet, in strict legal terms, each of the artists enjoys copyright in his work. Now, how are disputes about copyright violations adjudicated? The first and crucial test that a court will use is whether, in the eyes of a reasonable third party, the works in question appear similar or distinct. If similar, there may be infringement, but minor similarities will be disregarded. Very often, the evidence that is taken may come from different sources. For example, can the challenging author show something which indicates a close connection with the work predating the version under challenge? An example of this will be drafting notes that the author may have maintained at the time he was composing his work. And often this can get quite technical, but it is a good idea for creators to keep as much contemporaneous record as possible of their involvement with the work. Nowadays, this is much easier because you can have time dated emails and other electronic documents which are not easy to manipulate. It is worth noting, incidentally, that mere catchphrases or slogans cannot be copyrighted, but they can, in certain circumstances, be registered as trademarks. One other important point to note is that for a work, say a literary work, to enjoy copyright protection, it does not have to have literary merit. So the works of a profound writer would stand on the same footing as the works of a mediocre scribe, as long as both are the results of the respective author's labor and skill. Interestingly, even mundane products of creation enjoy copyright protection. For example, a bus timetable, because it requires some skill to arrange the timetable in a certain organized fashion. An interesting question that arises is, who owns copyright? As I've indicated, it is anyone who expenses labor and skill in creating an original work. And the concept of originality is important, as Swamy mentioned at the start of this talk. So in relation to literary works, it is the author, the person who wrote a book, for example. In relation to musical works, it is the composer, not the conductor, which is relevant for Western symphony works. In relation to artistic work, it is the artist. And as for movies, it is usually the producer. For photographs, it is the photographer. But there is a twist which needs to be noted. If someone is employed to produce a creative work for remuneration, then in the absence of an agreement to the contrary, it is the employer who owns copyright. This has huge practical significance because if you are, say, a staff reporter for the Times of India, when when a certain work is written, then the owner of copyright in whatever you write will not be you, but Bennett Coleman and Company. Although that position can be changed by contract, as happened with, say, uh, R.K. Lakshman, the cartoonist who worked for the Times, but who made his employer accept that copyright will vest in him. By contrast, if you're a freelance journalist, normally copyright will vest in you and not the media outlet which publishes your work. Why is this practically significant? Because if you want to republish your own work somewhere else later on, then if you don't own copyright, you'll have to get permission from the site where the work was originally published, for which you may be charged a fee. What about ghostwriters? This happens when, say, a celebrity whose desire to see his or her name in print far exceeds his or her writing talents. In such a situation, normally copyright would lie with the ghostwriter unless there is an agreement to the contrary. In practice, a lot of the time, the celebrity will give the ghostwriter enough money to keep him or her happy and in return take copyright away. By the way, two or more people can own copyright jointly. In that case, they will have to agree on the proportion in which they'll share the right, and of course, any royalties that the work may earn. Royalty, incidentally, is the money that an author is entitled to for owning copyright. So, to take a hypothetical example, if you write a book which is sold for, say, 1,000 rupees, and you have an agreement with the publisher for 10% royalty, then you will get 100 rupees for each copy of the book that is sold. How royalties are collected and distributed is a complex process, and it involves bodies called collecting societies. And that is a fascinating subject, which unfortunately I don't have the time to go into. Um, you may be wondering for how long copyright lasts. The answer is slightly complex. For literary works, which is the majority of works, it is 60 years plus the lifetime of the author. So, if an author writes a book at the age of 30 and lives until the age of 80, the book will enjoy copyright for 110 years. Originally, the period specified in the Copyright Act was 50 years after the death of the author, but something interesting happened which made the Indian Parliament change that term. It had to do with Rabindranath Tagore. He died in, I think, 1941, and so copyright in his works, which were extensive, would have expired in 1991 under the old formula. Royalties from his works used to go to the university he founded, Shantiniketan, and they must have run into millions of rupees. Just before copyright in Tagore's works was to expire, Shantiniketan appealed to the Indian government to extend the term to 60 years so that they could continue to enjoy the royalties for another 10 years. The government obliged. Then, when the 60-year period was due to expire in 2011, Shantiniketan again made an appeal asking for a further extension of 10 years. This time, the government put its foot down, and that's how the 60-year rule has stabilized. By a happy coincidence, the 60-year rule is also now becoming the norm in most countries. To complete the narration, the term of copyright for photographs, movies, and sound recordings is also 60 years, but from the time of the creation of each of those works. It is the same for anonymous works, 60 years calculated from the time the work was first published. Now, is it possible for a copyright owner to transfer his rights? The answer is yes. And the process is called assignment. All assignments must be in writing. And once the transfer takes effect, the person to whom the rights are transferred enjoys them instead of the original copyright owner. When a copyright owner dies, the right vests in his heirs and successors, including anyone who is nominated in his will. It is also possible for a copyright owner to allow another person to use the copyrighted work in a specified way, either for a specified period or forever. For example, you can allow someone to stage a play in which you have copyright. This kind of transfer is called a license, and licenses are usually issued on payment of an agreed fee. There is a controversial provision in Indian law which allows for what are called compulsory licenses, which can be issued by the government to anyone who has been unreasonably refused a license by the copyright owner in relation to an Indian work. This provision goes against the normal principle of contracts, but it has been accepted, rightly or wrongly, over the years. It does not apply to foreign works. Sometimes you can have an implied license. For example, when a person writes a letter or an article and submits it to the editor of a newspaper for publication, he doesn't have to say expressly that he's giving the editor a license. It is clearly understood. Talking of licenses, there is a very practical matter which is worth noting. You know that frequently companies or other bodies issue press releases, but with a condition attached that those press releases should not be published before a certain date. This condition is called an embargo. If anybody breaches the embargo, they can be sued for violation of copyright. Why? Because permission to use the press release is technically a license under the law, and you cannot breach a condition under which a license has been issued to you. An interesting case relating to embargoes happened some years ago, and it involved the Queen of England. She has a tradition of broadcasting a message to all her Commonwealth subjects around 3 p.m. on Christmas Day. The media are usually given a copy of the tape a few days in advance, mainly to take into account the differences in time zones and for media outlets to organize the telecasts in their own countries. On one such occasion, I think it was 1992, a cheeky tabloid newspaper in London published the text of the message 2 days earlier. The palace was not very happy and it threatened to sue the newspaper for violation of copyright. The paper apologized and agreed to pay, I think it was £200,000 as a donation to charity for the lapse. Talking of legal threats by royals, perhaps this is as good a time as any for me to tell you about how copyright can be used to protect a person's privacy. The case I'm going to talk about happened in 2005, and it involved Prince Charles, our king in waiting. He had attended the 1997 ceremony when Hong Kong was transferred by Britain to China, and he did not like what he saw. He has always had the habit of writing personal journals for circulation among a close knit group of loyal friends. And in one such journal, he said some unflattering things about this particular ceremony. Chinese takeaway, and he criticized the ridiculous rigmarole and awful Soviet style display of goose stepping Chinese soldiers during the ceremony. In addition, he referred to the Chinese leadership of the time as appalling old waxworks, and so on and so forth. Hilarious, but quite undiplomatic for someone in his position. The journal had been leaked, and one of the British newspapers carried excerpts from it quite prominently. Prince Charles sued, arguing that the publication was a breach of his copyright and also, of course, a breach of confidence. He won the case hands down. So, copyright is quite a handy tool to protect one's privacy. If, for example, someone gets access to embarrassing photographs, the way to stop publication is to apply to a court for an injunction. There is another high profile royal suit involving breach of copyright currently going through the British courts, this time involving the American wife of Prince Charles's son, Harry. Now, what are the defenses to a copyright violation? First of all, there is fair dealing, under which the law allows everyone to use limited quantities of copyrighted work without permission, usually for such things as reviews or reporting current events or research or private study or public readings or recitals. Now, what is limited quantities is sometimes contentious. It'll have to be determined against, first of all, the total size of the work, and secondly, against the background facts of the case. If, for example, there's a movie which is 2 hours long and a TV channel uses, say, 5 minutes in total of the excerpts from the movie for a review discussion, that would usually be considered fair dealing. But if a TV channel used a 9 seconds clip from the 100 meters running event at, say, an Olympics Games, that should be considered excessive because a champion like Usain Bolt would only take a little over 9 seconds to complete the run. So everything depends on the context. The important thing about fair dealing is reasonableness of quantity. Also, the source should be acknowledged. Incidentally, there is no limit on how much can be reproduced from official documents like court judgments or the official gazette. I will now tell you about a very controversial case which happened in Delhi involving fair dealing. By way of background, let me explain that generally speaking, when you use copyrighted material for educational use, the law is slightly more liberal than when such material is used for commercial purposes. But even so, there are limits. In the UK, students and lecturers are allowed to photocopy either one chapter or 10% of any copyrighted book without permission, whichever is shorter. And this is strictly for instructional purposes. But in Delhi University, within the precincts of the Delhi School of Economics, an enterprising businessman set up a photocopying stall in which he and his employees engaged in large-scale copying of pages from textbooks, apparently with the authority of the DSE, whose academic staff had allowed the owner of the stall to borrow the textbooks from their library. The shop, which was called Rameshwari Photocopying Services, would then supply the materials to students in so-called course packs at a price of 50 paise per page. Not surprisingly, when the practice became known, 5 prominent international publishers, including from Oxford and Cambridge, sued Rameshwari for copyright violation, which it clearly was. Shockingly, the Delhi High Court ruled against the publishers, holding in effect that as long as the mass photocopying was done for the benefit of students, it was excusable. An appeal was preferred by the publishers to a division bench, but it was withdrawn, reportedly as a result of pressures exerted on the publishers from various quarters. To any reasonable person, the position adopted by the Delhi High Court was clearly wrong. But in the absence of courage and tenacity on the part of the publishers to fight on, nothing further could be done. This state of affairs doesn't do India's reputation as a respecter of property rights and more broadly of the rule of law any good. I shall return to an important aspect of this case shortly. Meanwhile, to continue our narration, another defense to copyright violation is incidental inclusion. In simple terms, it means that if copyrighted material is used without permission in a reasonable way, but incidentally to something else being said or done, it would not amount to infringement. An example would be if, say, a person is shown in a movie sitting in a car waiting for his girlfriend, and to while away his time, he switches on the car radio where copyrighted music is being played. There would be no uh, infringement case in those circumstances. There is one other defense which is not explicitly mentioned in the law, but which I would argue uh, would or at least should be accepted by the courts. It has to do with the public interest. And it would mean that copyright will not be allowed to be enforced in any work that is immoral, scandalous, injurious to public health or safety, or involves a breach of trust, or is a violation of the law. An example would be, say, a book that is written by someone which has breached the Official Secrets Act, or a film that is pornographic in nature. As far as I'm aware, such cases have not come up before the Indian courts. But interestingly, the list of defenses listed in the Copyright Act has now become quite long because the law has undergone many amendments in recent years. There was one such amendment introduced in 2012, which brought in many new features, including that there should be no copyright in works created for disabled persons, for example, Braille books, and that playback singers and other artists could, if they so chose, negotiate royalty payments from producers or distributors. The Act also makes it legal for any literary, dramatic, or musical work to be performed by an amateur club or society if the performance is given to a non paying audience or for the benefit of a religious organization. Now, what are the remedies that are available to anyone whose copyright is breached? Very briefly, they can claim damages, that is, monetary compensation for any loss that they have suffered. They can also seek injunctions prohibiting anticipated breaches or further breaches. Furthermore, they can seek an account for profits that may have been illegally made by the infringer. On the criminal side, the Act allows for penalties on the infringer or anyone who aids or abets the infringement, including imprisonment for up to 3 years and or a fine of up to 2 lakh rupees. Two further points, and I'll be done. First, anyone who creates a copyrightable work does not have to register his work, although registration is possible and it helps in certain ways. Secondly, and this is one of the uncomfortable truths that I mentioned at the beginning of this talk, although it is tempting to assume that copyright is more a hindrance than a help, especially in poor countries like India, I would ask you to think more deeply and imagine what the long term consequences would be if people disregarded copyright and indulged in large scale copying without permission or without payment of license fees. Believe me, there will come a time when no new works of any value will either be created or sold in India because it will become unprofitable to do so. That is why there is a need to clamp down on copyright infringement. Unfortunately, India has got a bad name over the years, especially in relation to software piracy. And as the country grows richer and its population becomes more educated, there will be an expectation that public attitudes to copyright should change. To be fair, I would argue equally strongly that the corporate sector should also show reasonableness in the way they use copyright law, and in particular, that publishers and other copyright owners should not be greedy in their eagerness to monetize their rights. Ultimately, the situation calls for balance in this, as in many other areas. Sadly, the clock has beaten us, so I think I'll stop here. Thank you.
is I have three questions. Is it necessary work to have some distinctive originality before you can claim copyright? I mean, before your matter can be registered under the Copyright Act, so that if somebody else replicates that, then you can sue him and for damages. So if it is, supposing I wrote a book on Taj Mahal, my visit to Taj Mahal, and I gave different angles about what was in the basement, what was the I covered an area which everybody knows, whoever has visited Taj Mahal, and someone else just reproduced that and put his name as the author. Would that be a violation of copyright? Is question number one. Question number two is, I write a book in English on, say, calculus, and someone translates that book into Tamil and puts his name as the author. Does that come within a copyright? How do I prove?
Yep.
Because calculus is not, is not no more. It's 300, 400 years old. I'm just, as a teaching aid, I'm producing a book.
Yep.
And the other person, he doesn't refer to my book at all, but translates my work into Tamil and then publishes his own name. So how does the copyright?
Yep.
Finally, patents generally have a time limit. Do copyrights have a time limit?
Yeah. Okay.
Specified in the Act.
Yeah.
So these are the three questions.
Yeah. Taking it backwards, the first, the third question you asked is very easy to answer, which I actually described at some length. Copyright also has very fixed time limits. In the case of in the case of literary works, which is the majority of works we're dealing with, as I said, 60 years from, it's actually a complicated formula. So it is 60 years from the start of the calendar year following the year of the death of the author. So for all practical purposes, the lifetime of the author plus 60 years. So if a person was a genius and wrote a book at a very young age and was lucky enough to live for a very long time, then the period of copyrighting that work will be extensively long. But if, on the other hand, a man wrote a book just before he died, then all that the people who enjoy copyrighting his works will be for 60 years plus whatever remaining time. So quite easy. 60 years is roughly the general formula to use. Okay.
Now,
going back to your second question, which was about translations, also very easy to deal with because translations enjoy separate copyright. So if somebody wrote a translation of your work, but do remember that the person who is going to write a translation will have to seek your permission in the first place, because the original was your work and he can't.
Supposing he doesn't. Supposing he doesn't. Supposing he doesn't, pretends they don't exist.
If he doesn't seek
and
permission.
he translates it, and then how do you say? How do you say that this is not an original work in Tamil?
Okay, for that you're talking about a matter of evidence, not copyright law. So what happens is,
I mean, copyright law may apply, but how do I apply it?
Okay, how do you do it is based partly on documentary evidence. So one easy way would be if you have published your original work, which in many cases happens, but in some cases doesn't. So if you've written a book but you've not published it, and somehow the other fellow gets hold of your manuscript and tries to translate, in that case you will have to show. Now, in an extreme case, you can actually persuade the court to apply carbon dating and to show that your manuscript was written 20 years ago, 30 years or whatever. But there's an easier way of solving this problem, and that is, even if you don't publish a work, as soon as you write something, you can have it registered, and registration is fairly simple. So once you register, proof is not difficult.
No, you're giving me an esoteric case. I'm simplifying. I published a book.
Yeah,
it was described in a course and all that. Somebody went and translated it.
Yeah,
I'm not giving you some crazy example. The Russians were doing it all the time.
Yeah.
Any book in science was produced in American education. They translated into Russian,
Yeah.
and then sold it at a very cheap price.
Yeah.
So because there was no hard work to do, all you had to do is translate
Yeah.
and never acknowledge the original author.
Yeah. That is because, unfortunately, a principle that is very dear to your heart and mine, namely the concept of right to property, did not exist in the Soviet Union.
Yeah,
So
correct.
you
So
cannot,
you
and
have to be,
also
the two countries have to be parties to a copyright act. That's what you mean.
reciprocity.
Yeah,
But even
reciprocity.
more than reciprocity, there should be the rule of law. Imagine
Yeah.
going to a Soviet Union court and trying to establish your case, even if you were on velvet. Impossible.
Yeah.
So anything that I say is subject to the most fundamental condition that there
Yeah.
is rule of law. And quite frankly, why go to the Soviet Union? Even in India, it's a problem. I know of many foreign movie producers who are finding it impossible to assert their rights in the Indian courts. And all
Yeah.
these Bollywood producers are
Yeah.
copying Western movies left, right, and center. Now, it is
Yeah.
not as if these people can't prove that they have published, they've created the original works. It is simply that enforcement mechanisms are so weak, almost non existent. And so, in a sense, you're not talking about the substantive law, you're talking about
Oh,
enforcement.
okay,
Yeah,
one subsidiary question. How do I
yeah,
know that somebody has produced a work originally? Somebody else. The idea came to me and I
yeah,
published it, and I find that somebody in 20 years ago or 40 years
yeah,
ago
yeah.
had already foreseen it and published it.
Yes,
So
possible.
I have a complete ignorance, no?
Yeah, well, it is possible, but that is where the very important principle of copyright law comes in. Namely, copyright does not protect ideas; it only protects the expression of ideas.
That's
So,
right.
if you had an idea about a certain concept, that concept is not copyrighted. It is how you express that idea, and almost invariably, two people will never express it in exactly the same way. There may be slight differences. Now, of course, trivial differences will be ignored by the law. But if you can show, as a matter of evidence, that what you did was sufficiently original for it to stand as a copyright copyrighted work, then if somebody copies it, they will not be able to show, they will not be able to claim that the idea came to them and therefore they wrote. Of course, the idea may have come to them, but how they express the idea is more important.
Okay. All right.
And
And
that also
finally,
applies incidentally to the first question you asked about the Taj Mahal,
yes.
because what is happening is it is not the concept of the Taj Mahal having so many levels of
Mm,
so many stories, a ground floor, a basement, and all. It's not that.
mm,
It is how
mm,
you express it, and it'll be extremely rare for two people to use exactly the same words to express what they see. Although it is possible, as I said, the example I gave of somebody sitting outside the Taj Mahal and
mm,
making a drawing of the Taj Mahal. Now, in those circumstances, they can be absolutely identical.
mm.
So there
Okay.
will be problems. But
I'll
the
give
law
you.
does
I
deal
don't.
with those
I don't want to
situations.
I don't want to monopolize you, but others want to also, I'm sure, want to ask. But one example I give you:
Hmm,
uh, 1,000 monkeys were produced in a laboratory,
hmm,
and each was given a typewriter,
hmm,
and they initially taught them to just press the keys. And all thousands. This is a real example of a mathematician called Poisson,
hmm.
Poisson, and so he found that 1,000 monkeys typing away, one of them actually typed a Shakespeare's sonnet,
Hmm.
because in this random hitting of keys, one of them came to actually type a Shakespeare's sonnet.
Hmm.
So, therefore, a rare event in a very large number of a very large number of experiments can produce a thought which somebody else had produced. I mean, these are sort of outlier cases, but I'm just mentioning to you that it's possible that two people
Yep.
repeated the same English,
Yep.
or at least in translation the same idea in a translation in Hindi or Tamil or whatever.
Yeah.
And so I think the law is very hard to enforce. I would say finally that 60 years is too long. The patents are not more than 14 years nowadays.
Yeah.
In the new WTO document that we produced,
Yeah.
it's only 14 years. India had 20 years. Then India was forced to reduce it to 14 years. So when an original patent has only 14 years, how can an original essay have 60 years?
Yeah. But then you see the greed of institutions like Shantiniketan. They were not even content with 60 years. They wanted it extended further. So
yeah, they probably wanted the language also be treated as their intellectual property.
Or probably wanted copyright in perpetuity, so that they can continue to enjoy royalties. So
Right.
ultimately, a balance has to be struck.
Sure. Okay.
I
Jagdish?
have just a quick comment. Go ahead, Jagdish ji. Go ahead.
No. I am talking about many of these Indian ingredients like turmeric, yoga, and
Good question.
many of the other items. I believe a lot of Western institutions are doing copyright, and we, the general people who have been using it or experimenting with many of these things, whether it is tulsi or whether it is neem and all that.
Or cow's milk.
Yeah, A2 milk, cow milk. How do we protect some of our ancient cultural heritages?
Okay, they come under a completely different category of intellectual property, not copyright at all. Geographic indicators, traditional medicine, this, that, and the other. So that is a very, very complex area, unconnected with copyright, and there is still a lot of dispute about many of those cases. But the law is becoming more and more stable in those areas. But they're completely outside copyright.
No,
But patents have only 14 years. If 14 years elapsed since cow's milk was discovered, then there's no patent.
Well, no, I would like to say, for example, if somebody was to register a trademark haldi or neem in the US,
it won't be registered. Register for what?
No. I mean the name or your product. There is a difference. I can call myself Neem, some product Neem, and put a computer for it. Now that you can't stop me from doing that.
No, he means the product.
How can you copyright Neem? You can copyright a name.
The creation of
patent. You can only formulation. Formulations cannot be copyrighted. Formulations can be patented.
If their patent is only 14 years.
Correct. So turmeric is more of a my 2 cents on this. My 2 cents on this is turmeric. All these things are patentable, not copyrightable. Venkat, you can correct me if I'm wrong. That's my understanding.
Can I say this? Actually, there are so many concepts involved here. So in a sense, we are confusing too many things. And actually, I'm quite happy if you want a larger discussion on that aspect to do it separately, because they are completely different, very, very complex actually.
Okay, we can follow it up next week then.
Yeah, it's neither trademark nor copyright. It is something much more sophisticated than that. Okay. And it's an area of the law which is still evolving. Okay. But in the last, I would say, 20 years, there has been a degree of stability. So, maybe on a later occasion, I'll quite happily deal with those.
Yeah, because it's important, because it's more of a formulation. The turmeric is a formulation. Because the way recently I've been reading about, the guys are skirting around this. They're putting it in a capsule. And they're just getting around the stuff. I mean, they're all creativity. I mean, crooks have they're very creative generally. So,
for example, before we started the program, I gave you an example. I'm told, I do not know whether and under what law, Siddha Yoga.
Yeah.
The use of the word Siddha Yoga has been copyrighted, I'm told, in the US.
No,
so anybody even referring to it finds it difficult in his books or on a discussion. Say, example, Swamy Chinmayananda. Suppose I'm just giving an example. If somebody was to register the name Swamy Chinmayananda, there are some laws, I'm told, that you can't use or refer to his name. Looks very ridiculous, but we have got so many complaints and cases where people in India find it difficult to challenge these Western registrations.
No, Jagdish, with respect, the person who has drawn your attention to the case is quite mistaken. And I'm quite happy later on. It requires a very, very long explanation. I'm quite happy to explain it to you either offline or in a subsequent program, because these are issues which involve so much complexity that I will need to actually also lay the ground for the discussion. And it is
Surely,
impossible
I'll
do
ask
it
them to
in a program
contact
like
you,
this.
or if they are watching this program, send
Yeah.
you an email at legalwordsofwisdom@gmail.com, which is scrolling on our screen right now. When Ramesh has a question.
Yeah, no question. I'm just observation on what Jagdish just said. I just looked up Jagdish about that Siddha Yoga. Essentially, what they're saying is they're not copyrighting Siddha Yoga, but they're saying Siddha Yoga as taught by SYDA Foundation in a certain set of books and videos are copyrighted. I mean, even though they're being smart, as I said, like because Siddha Yoga is copyrighted, that the word WhatsApp message that are spread, but actually what they're saying is Siddha Yoga as taught by SIDA Foundation, SYDA Foundation, is copyrighted, which is actually correct. But anyway, I just want to mention, Dr. Swamy, more in jest, you talked about that monkey story. So is that so? Luckily, Shakespeare was not alive; otherwise, he would have sued the monkey.
No, but I think as Venkat
But
mentioned,
Shakespeare cannot sue because
No, if he were alive,
works are completely out of copyright.
No, alive.
No, even if he was alive.
Oh, you mean that?
Expired. Okay, you're right. If he was alive, he could, because copyright exists for the entire duration of your life plus 60 years.
Correct.
Yeah,
that's what I said. Yeah, even if he were alive, he would have sued.
Yeah.
One interesting thing, Venkat, you mentioned about the composer, right? The guy who Ilayaraja successfully sued and won in Madras High Court that he has. I'll give you the exact term that they're using. He used the he wins a copyright case. He entitled to special moral rights to over 4,500 songs, because what happens in concerts and all those things, people sing his songs, including SPB. They had a argument or a tiff over that, and the organizers who created these music festivals, or I mean concerts, sold those things and made money. And Ilayaraja said, "You cannot do that."
No.
So I own the right.
Yeah.
To so I'm just a very important topic. I'll send you the link, because it's it was a very famous suit that was going on in Madras High Court, and Ilayaraja won that case.
Yeah. Talking of Madras High Court, there's another even more high-profile case which came up many years ago actually, involving, of all people, Nani Palkhiwala. Nani Palkhiwala was sued by a lawyer in Madras called Sampath Iyengar, alleging that Palkhiwala had plagiarized this Sampath Iyengar's book on income tax. Now, you know that the most authoritative book on income tax in India is written by Palkhiwala, along with his old senior, a man called Jamshedji Kanga. So this case was actually heard by the Madras High Court, and there was a lot of bad blood evident in the whole thing. Palkhiwala was cross-examined as to whether what he wrote was original or whether he copied from Sampath Iyengar. That's where the importance of evidence comes in. And ultimately, of course, the court came to the conclusion that Sampath Iyengar was trying to bring up a case without any basis, and the case was dismissed. So evidence is important. And as I mentioned in my talk, one way in which you can try to secure your claim to original works is by keeping drafting notes, or for example, when you're writing the work, you would normally nowadays do it on a computer, and your computer will be good evidence as to when you wrote it and what corrections you made, etc., etc.
So there was one question that just came up about Veda being copyrighted in Germany. Again, it all comes to the same point, Venkat, that we need to have an extensive discussion on. Veda as a software is not the same as Veda as Veda. So there's no way you can copyright Vedas per se. Just a term. And Veda written in English can be copyrighted anyway, if that country allows that, right?
And then, of course, it gets even more complicated nowadays with what are called geographic indicators.
Correct.
So I can't think of anything immediately, but as a very rough example, I would say the petas which are made in Mathura, about which one hears from time to time. Now, if somebody made the same product somewhere else and then sold them as Mathura petas, then they would be infringing what is called geographic indicators. So there are so many concepts which I will quite happily deal with if there is any interest in a separate episode.
Yes, Dr. Swamy.
No, I was saying that, as he said, that we can do a separate thing, taking it forward in terms of all the various subdivisions, as you pointed out, geographical indications, copyright, patent, and so on. And then I conclude it in another session, if you like, because we already crossed 9 o'clock, I think. Yep.
Yes, we're just on at 9. Okay,
Yeah.
friends. Thank you, Dr. Venkat Iyer and Dr. Swamy, for this interesting session on the subject we just discussed on copyright. And I thank Ramesh Swamy for co-hosting this program with me, and also thank the technical team led by Ashish Shetty, Tejas from Pune, Vishal Mehta from Mumbai, Ishwar Iyer from Navi Mumbai, Rakesh Gadgi from Karnataka, and Swaminathan from Chennai for their background support and helping us to put this weekly program of Nyay Gyan Ganga, Legal Words of Wisdom, together. We will be back on next Saturday on the Legal Words of Wisdom, Nyay Gyan Ganga. But tomorrow at 8 p.m. we'll have our regular topic of Words of Wisdom, Gyan Ganga. So please keep in tuned for the Sunday edition at 8 p.m. Indian Standard Time. And I thank all our viewers across the globe for their support. Any questions you have on this legal version, you can always contact us at legalwordsofwisdom@gmail.com, as it has been scrolling on your screens. And Dr. Venkat Iyer will be more than happy to get back to you on some specific questions you have. But as he has volunteered, we may have an extra session on this subject, or some of the aspects or diversions of this subject. So as I mentioned, legalwordsofwisdom@gmail.com is our email ID. You can definitely send an email to Dr. Venkat Iyer and he'll be more than happy to respond. Thank you, viewers. Jai Hind. Dhanyavad.
Thank you.